Welcome to our latest podcast. Today, we're going to talk about bankruptcy issues and divorce. I'm Gwendolyn Sterk, and I'm a practitioner in family law in Orland Park, Illinois, and I'm pleased and honored to have with a colleague of mine, Firas Law, and we're going to go through and talk about various bankruptcy issues. Welcome.
Thank you for having me. I appreciate it.
Sure, no problem at all. This is a lot of information for people to handle because I always say to people, I don't understand the language in your area where you work, and you don't understand all the language in our area. And it's one thing to be conversant in family law, and it's an entire separate matter for you to be experienced in bankruptcy. So we're pleased to have you come on. You do a lot of work in bankruptcy, and so we can get some background and get some basic information. What is bankruptcy in general?
Well, bankruptcy is federal law that if a consumer, we'll just talk about consumers for our aspect of our conversation, is if they qualify financially and they qualify asset-based, they may qualify to file for bankruptcy, which ends up discharging or getting relief on certain debts that they are obligated to pay. Obviously, there is something called means test, which means you can't walk into a bankruptcy. You have to financially qualify for it. And not getting too much into it, the means test is basically calculating your income received within the past 6 months. And if that number falls below the poverty level that's set by the United States trustee or the census, if you fall below it, then you qualify for a Chapter 7. If you don't, then you would have to qualify for a 13.
Now, these different chapters seem very complicated to people. So can you tell us what's the difference then really in effect from a Chapter 7 to a Chapter 13?
Sure. So the simple aspect of it is a Chapter 7 is what everyone thinks a bankruptcy is. It's called liquidation. Chapter 7 will eliminate most debts if you qualify for it. And when I say most debts, example, student loans are not dischargeable, certain tax arrearages are not dischargeable, child support and maintenance arrearages are not dischargeable. Now, what if someone doesn't qualify for a 7? They would be forced to file either no bankruptcy or a Chapter 13. A Chapter 13, long story short, would be repaying back your creditors for a term of anywhere from 36 to 60 months. And depending on your asset structure, you could pay back your creditors 10 cents to a dollar or a dollar for dollar.
Understood. Now, what would be some reasons that somebody would want to really consider a bankruptcy? Is there a certain amount of debt that you have to accumulate before you'd advise somebody, really take this step, you really need to utilize these federal laws?
Correct. It usually, I've been practicing bankruptcy for a good 9 to 10 years. And out of my experience, it's never been an amount that broke, the camel's back, as they say. It's usually the emotional stress of how much a debtor or the consumer can handle. Usually the breaking points that I've seen, and from my experience, would be small claims lawsuits that are just piling on, or citation to discover assets. That's applicable in family law as well. Usually that type of proceeding will just push the debtor over to seriously consider filing bankruptcy.
What's the ramifications of a bankruptcy on your credit as compared to just letting that debt kind of sit there, so to speak?
So the credit implication would be 7 years. The credit bureaus don't tell us what the formula is because it's considered their work product, but from the outside in, it's usually around 7 years. And it does show up under the public inquiry judgment notices portion of your credit report that we've all seen in our legal professions. Just as a note, if you do file for a Chapter 7 or 13, it usually does say bankruptcy. It usually says the Chapter 7 or 13. And I just found out maybe a few years ago that, example, my name as the attorney would show up on your credit report as the attorney representing you. As a word of caution, depending on the type of bankruptcy, so if it's a Chapter 7, if you do file a 7, you do get your discharge, you may be barred from applying for a mortgage from anywhere from 3 to 7 years, depending on the type of mortgage you apply for. And not deviating, but that's one of the considerations we talk about with my clients if they want to file a 7.
Right. So you really have to, it's serious business. You have to consider the ramifications. On the other hand, if you're sitting on debt and you're never going to get it paid back, you might as well take some steps, obviously, to give yourself some relief, which is the purpose of the law in the first instance, correct?
Absolutely. And one of our statutory duties as bankruptcy counsel is to advise a potential debtor of their bankruptcy options and their non-bankruptcy options.
Got it. Understood. Now, it's interesting. Somebody files for divorce and one party says, hey, I want to get a bankruptcy and get rid of this. And the other party says, no, I don't. So let's first talk about if they're not yet divorced, but going through a divorce, what do you recommend to people? Should they consider joint, or what's the ramification of somebody filing on their own?
Well, talking in a vacuum, it would always be easier and cleaner if both parties could cooperate with another. And obviously, once they get to the dissolution portion of it, they're usually not really cooperative. But all emotions aside, it would be a lot easier, a lot quicker if both parties file for a 7, if they qualify, to eliminate the debt, most debt, obviously. And what that would do is if they file for divorce, as you have been practicing family law for quite some time, the marital estate doesn't have much debt to allocate. So it would make it easier.
Got it. And let's say that one party absolutely doesn't want to file. What's the ramifications for one spouse filing and the other spouse not?
Absolutely. It's very common for one spouse to file for bankruptcy while the other spouse doesn't. That's common and it's acceptable. You would just have to properly disclose it in the bankruptcy that either the parties are married but separated. That deals with different aspects of how to calculate their income. However, what that does is if there is no bankruptcy petition, if there's no divorce on file, then only one debtor would get the discharge and the other debtor won't. So example, if there's a joint credit card, husband would be discharged, the wife wouldn't.
Sure.
Now, if there is a divorce pending and one spouse files, let's say the husband in our example, then that does put the divorce matter on pause, the automatic stay, until the automatic stay gets lifted or modified, or you read 520 section 362, which is the automatic stay section, which we'll get into detail later. What matters can be heard in divorce court without impeding the automatic stay.
Understood. And is the same true for an automatic stay, whether it's a Chapter 7 or a Chapter 13?
Yeah, so in our conversation, Gwen, we're assuming that there is a normal bankruptcy filer, because if you are a serial filer, which means you file bankruptcy repeatedly,
right,
you don't get the automatic stay. It has a very short life. But for our purposes, normal debtor first time, yeah, Chapter 7 and a 13 and a Chapter 11 does impose an automatic stay.
So let's say that one spouse files and gets a discharge from a certain debt, and then the other spouse carries that debt. Can the divorce court allocate that remaining debt that belongs to, in this example, the wife?
Yeah, so there is, I've represented a handful of spouses in this exact situation. I actually have one pending before a court right now. I'm not going to say the name, not the judge, but I actually have this issue before a judge as we speak. The answer is you cannot discharge the marital estate. The marital estate does need to get repaid back. So there's 2 cases that were rendered by the Illinois Appellate Court, 2 of them, one called Sessa Reddy and Lee. Basically, what it comes down to, where if one spouse is, per your example, files for bankruptcy, gets a debt discharge, but the wife is still held liable, a divorce court should be able to tell or order the husband to reimburse the marital estate, not the creditor, obviously, but the marital estate, some portion of that debt that the wife is now stuck with.
And that's very interesting. So, also if one spouse files for bankruptcy and loses certain assets, like surrenders a vehicle, that may have had some equity, could the court then, the divorce court that is, rearrange and reassign that asset?
The answer would be most likely no. So if you remember back in law school, federal law is a supremacy law. It takes over state law. So in this particular instance, if one spouse files for bankruptcy, then the entire marital estate becomes under the jurisdiction of the bankruptcy court. And I've held multiple seminars regarding this issue in different counties, one in McLean, one in Will County. The biggest advice that I could give for the wife, in our example, the non-filing spouse, is to participate in the bankruptcy, because if you close your eyes or you turn your cheek the other way, you have lost your ability to adjudicate or even at least put your claim on file with the bankruptcy court regarding your interest, marital interest in that car that you just mentioned.
Understood, right. And so it's important, if somebody is in the process of a divorce or one spouse has filed and the other hasn't, you still need to, would it be your recommendations for that non-filing spouse to consult with a bankruptcy attorney?
Yes. The non-filing spouse could do what they wish for our recording purposes, but I always recommend that if there is a legal proceeding, you should always have an attorney on hand, because again, our language is a different language. So I have represented multiple wives. It always happened to be in my area of practice. I've always represented wives. I don't know why, it just happens that way, but I have represented non-filing wives where I brought them into the bankruptcy. Either I brought them in as a proof of claim or actual an adversary, so they could at least adjudicate or put on file their marital interest claim in the husband's, example, bankruptcy.
Right, and then the bankruptcy court would rule from there. Now, let's change the hypothetical a little bit. They're already divorced, and there's a divorce decree that obligates somebody to pay maybe a huge credit card debt of $100,000, and the spouses are each supposed to pay $100,000 on this bankruptcy or on these credit card debts, and now one spouse files a Chapter 7. Does that escape your obligations under the judgment if you file a Chapter 7?
I think the analysis would be the same as you can't discharge the marital estate. And this is tricky because we all know that property settlements are not modifiable in bankruptcy. I mean, in divorce court. So this would be one of the instances where the non-filing spouse would have to consult with an attorney, because what would need to happen would be either filing a proof of claim or an adversary determining that that portion of the debt shouldn't be discharged or should be known to the bankruptcy court that that judgment is under either a domestic support obligation or under a property settlement. And that would obviously matter depending on whether it's a Chapter 7 or a Chapter 13. It's not something I would have the non-filing spouse ignore.
Absolutely. And what's the difference between the post-judgment filer of a Chapter 7 versus a Chapter 13?
Well, it depends. So if we're talking about domestic support obligations such as maintenance, child support, support for the children, medical, education, and so forth, those are not typically discharged in either a Chapter 7 or a Chapter 13. You just can't discharge your obligation. It's just too high of a priority to be discharged. And that falls under Section 523, A5, and A15. And in our purposes for our podcast, we're not talking about statutes, but that's what the citation is. Now, if we're in a 13, which is that payment plan we're talking about, that we talked about earlier, property settlements may be discharged in a Chapter 13 if the Chapter 13 is completed. And that's why I strongly encourage the non-filing spouse to act as a creditor and make her claim known to the Chapter 13 trustee and the bankruptcy court of her interest, so she does not get adjudicated and left with nothing at the end.
Understood. So it's real important. Now, if you have a huge amount of child support that's past due and owing to you, and maybe it's $60,000, and somebody files a 13, are they going to pay that back over time? Is the divorce court going to be the one to determine how that's paid back? Let's hear about that.
Well, that's pretty interesting. So number one, I've had this case before, and of course, clients are not really honest. So I'll give you the example of this case. It's a public record, but I'm not mentioning the name. The husband owed child support arrearage of a great amount. He filed a 13, and the wife came and hired me and retained me as a creditor, as a priority domestic support obligation creditor to challenge the 13. So after a review of the Chapter 13 plan, we realized her $60,000 example child support wasn't listed on there. Now, what happens? The question is the arrearage doesn't get discharged, but what does happen is, number one, the debt owed to her for child support doesn't get paid back in the Chapter 13 plan. And number two, the automatic stay is in effect, so she can't go to court to collect on it while the Chapter 13 is pending. So if she didn't act and the debtor completes his 13, she can't do anything. Interest stops typically, and she can't collect. But here's the trade-off. Under a Chapter 13, the debtor has to file an affidavit with the court saying that his child support arrearage is paid off. If it's not paid off, he doesn't get his discharge.
Understood. Okay.
So there's an incentive there. So to answer your question directly, the bankruptcy courts are not going to make him pay his child support arrearage for our example.
Right.
They'll just hold it over his head they will hold his discharge until he pays it off.
Understood. These are very complicated issues, and I know that a lot of people over my 32 plus years doing business in this field, they don't understand a lot of these moving parts, and it's a very complex area of the law. It's not something that's very simple, and I've heard you say throughout the podcast, well, it depends, and I think that becomes a little frustrating because there's not a straightforward, clear answer in a lot of instances.
No, there isn't. And just like, I've done divorce work, heavily with Mr. Grata, but I'm not as experienced as you or him. But every client has their own unique set of issues. And I wish we could live in a legal system where it is cookie cutter, but unfortunately it's not. So the best approach I have with my clients, and I'm sure you do, is we sit down and talk to our clients and say, this is complicated. This does have a lot of moving parts, but we're here to hold your hand to get you through it the best we can.
Understood. Tell me what happens with attorney's fees.
It depends.
Yeah, there you go.
And again, and
Right.
I'm not being a smart aleck, but
Right.
it really does it depends on the facts and circumstances. So the general rule is, if it's your client, let's say it's you, Gwen. Let's say you represented wife Sarah, and she owes Gwen Sterk's law firm $30,000, and she files for bankruptcy. There's not really much you could do to stop it, unless you could find a way to lodge a fraudulent action against her, such as, misrepresenting her financial statement to you or making false promises. Then that's a conversation we could have. But if there is a judgment saying that your client Sarah wife or ex-wife, owes your opposing counsel money, or attorney fees, those could be non-dischargeable pursuant to 523A5 or A15.
Because they're obligated as part of a court order and a judgment, correct?
Yes. Okay. Mostly, and you're absolutely correct, but most likely it's going to be A15 of non-domestic support obligations, but related to a domestic court order. So that could be it. Now, that's pre-decree. Let's talk about post-decree. Let's say, someone hires you, as they've done in the past multiple times. Hey, Gwen, my ex-husband is not paying me my child support.
Right.
He owes me $60,000. That example, go after him. And I've seen you do this multiple times. That's what you do. You go in, you file the rule, and let's say you're successful. I've seen you be successful multiple times. Now, you're not free, Gwen. So you file your fee petition at the end, correct? 508, that's just
Right.
normal practice. And let's say you're successful on that, and Judge whoever grants Gwen Sterk's firm X amount of money for their attorney fees. And the judgment's is in favor of your firm against ex-husband X for domestic support obligations for not paying child support. And he files for bankruptcy and puts your firm as a creditor. I've represented a lot of attorneys in there where I've come in, and so far I've been successful that your attorney fees are attached to the support of a child.
Correct. Right.
And therefore, although your attorney fees are attorney fees in nature, but they were designed to enforce the support of the domestic support obligations, i.e. a child support order. Therefore, it should be considered one of the same, and therefore your fees should not be discharged.
Right.
I've been successful a few times with other attorneys in our Will County area. I'm not going to name their names, but I've represented a lot of them in Will County and some in Cook. I've been successful on that. Again, depends on the circumstances. No guarantee in podcast that it will apply for you, obviously, but it's one of these matters where, as your law firm, you should not ignore the bankruptcy notice that you get.
Absolutely. And also then your client, because you have a contract generally with your client, that there's going to be an obligation to pay if the other side doesn't actually pay you. So it becomes this real circular argument.
Correct.
Tell me about the distinction between child support and maintenance. Is there a distinction, or are they all domestic support obligations as you described?
No, they're usually, they fall into the realm of a domestic support obligation. So section 101.14a has a 4-element requirement of what is deemed to be a domestic support obligation. Typically, maintenance, alimony falls into that category. Your garden variety child support falls into that category as well.
Very good. Again, very complicated, and I could spend another, half hour with you on some more complicated issues, but I do want to direct your attention now to the recent time that we've gone through, with COVID. And I know that people are still getting benefits right now, but has there been any change for you? Or do you see maybe the business side of bankruptcy higher or the consumer side? Can you tell us a little bit about what your observations are?
Sure. My individual observation, and not speaking for the state level, county level, or other attorneys, I still get my, normal consumer cases, but they're not flooding in as we heard on the news that was going to happen. My personal perspective is I still believe that the state of Illinois is still funding unemployment, still offering the federal stimulus on top of that. I think that expires at the end of September, if I'm not mistaken. In my personal perspective, I believe that since that is still in effect, consumers haven't been filing for bankruptcy. I assume or presume that it may happen once the stimulus ends, once unemployment ends, maybe sometime after the new year. Usually consumers don't file or reluctant to file during Thanksgiving and Christmas. That's usually family time, happy time.
Sure.
They don't want to associate a difficult matter such as divorce or bankruptcy during those times. So I would tend to see, I would assume to see consumers filing maybe sometime after the new year. In terms of businesses, I've seen more small businesses file for bankruptcy now than I have with consumers. I've represented multiple small businesses, wind down their businesses, file for a 7 to get their no asset report, and just move on.
Sure, and having been affected, so there's a lot of different consequences for this action. So if you're out there today and you're listening and you're saying, this has really destroyed my marriage, the economic consequences here are something that's very, serious for us. Sometimes when people come in for a divorce consultation, I have to tell you that I think that their issue really is maybe seeing a bankruptcy attorney first, because maybe if they could avoid some of those financial consequences, their relationship could be restored. I think that also is a perspective that we all have to look at, but the struggles that you have are real, and there is help out there is really the answer. And so reaching out to you is something that you can do. Can they call you for a free consultation? How do you work your consultations?
Correct. So my consultation, the initial consultation is free. Anywhere from half hour to an hour is more than needed. I'm in Mokina, 191 in LaGrange. My address is 18927 Hickory Creek Drive, Mokina, Illinois, and I'm in suite 115, so first level. And my direct office phone number is 815-450-9340. And they could call and make an appointment.
That's very good. So we really appreciate your time today, because I think that this is something that people need to seriously consider. And I think that people haven't paid their mortgages. They haven't paid rent in a long time. And there's a lot of people out there saying, I know that this has been extended, and they keep, I call it, put up the carpet and shove it underneath and ignore the situation. But sometimes, and at some point in time, you really have to look at what your options are, because there are options, right?
Absolutely. So just like your field, Gwen, I think the most difficult aspect for a client to consider either filing for divorce or bankruptcy is making the appointment. In my perspective, that is the most difficult decision to make. And once they walk into the office, I've had clients say, I feel so much better
Sure.
than I did walking in, because one, I'm walking out with knowledge, and two, I'm walking out with options that I didn't know that was available to me.
Right.
So having the consultation with you or with me or with any attorney they're choosing, obviously, these clients should absolutely go out and get some knowledge, speak to a professional. Unfortunately, that's us. Speak to us. We'll tell you the truth. We'll tell you what your options are. And at the end of the day, they are the bosses. They get to make the decision.
Absolutely. So, you know, there's resources out there. That's the reason why we do these podcasts, is to share information that we've learned and gleaned, and to share resources within the community. So we would encourage you to listen to the information and make sure that you are taking part in what's available to you. So thanks so much for your time today. We really appreciate it.
Thank you. It was good to see you. Thank you for having me on. And of course, just as a disclaimer, no legal advice was given to anybody in particular. This is just a conversation between two old friends that we haven't seen each other in a while. But I am more than willing to come back if you wanted to discuss more detailed, more complex issues if needed.
Very well. Thank you so much.
Take care.